Right, good morning everybody. My name's David Pett. Welcome to this, the latest in a series of occasional webinars on matters which we hope will be of topical interest to you. Today we're going to look at HMRC's policy as regards settlements of employee benefit trusts, and my partner Stephen Woodhouse is going to take us through all the issues that arise in relation to the announcement made by the Revenue that the opportunity for settling is soon to come to an end. So first, can I introduce my partner, Stephen Woodhouse. Stephen, good morning. What are we intending to cover this morning?
Morning, David. What we want to do is to cover the issues relating to EBTs and the current position with regard to the revenue challenges, looking at an overview of EBT planning, spending some time looking at the revenue's historic approach, thinking about the impact and opportunities of the settlement offer, talking to some extent about the experience that we've had collectively with EBT settlements and negotiations with HMRC, moving on to discuss the scope for continuing to seek settlement prior to 31 March 2015, and as will become apparent, the significance of that date is that is when settlement negotiations need to be commenced in order to be able to come within the settlement offer, thinking about the impact of disguised remuneration, and finally looking at some of the issues regarding the management of EBTs post 31 March 2015.
To begin with then, Stephen, what is an EBT in this context?
Well, I think that's a very good starting point. I've heard it said that the Revenue have difficulty keeping on top of all the different types of EBTs which are out there. The phrase EBT just stands for Employee Benefit Trust. I've heard it said somewhat satirically that in the annals of HMRC, the E stands for Evil Benefit Trust. That's probably an exaggeration, but I think it shows to some extent the way the Revenue view offshore employee trusts with some suspicion. For our purposes, and this is in contrast with other forms of employee trusts, we're looking at an EBT as being a trust for employees generally, but with sub-trusts or sub-funds, each for the benefit of a particular beneficiary and their family. So we have the assets in effect segregated off, or to use the language which comes from the disguised remuneration rules, earmarked for particular groups of individuals. The nature of the trust, however, is still discretionary, and therefore the responsibility for managing the trust assets will remain with the trustees, which, as we will see when we come to talk about the legal position, is a key part of understanding the way that the tax works with these sorts of trusts.
So how exactly has HMRC sought to challenge the use of such EBTs?
The Revenue's challenge has been continuing for some time. There was an announcement back in August 2009 that the Revenue were going to attack EBTs, and this announcement was in Spotlight 5, attack EBTs by adopting a position which in essence said that in their view, where you had an EBT of the nature that I've just described with sub-trusts or sub-funds, that the Revenue were of the view that at the point when the assets were allocated into the sub-funds, that the reality of the analysis was that the individuals at that point had access to the money, unreserved access to the money, and by reference to some old case law, that was sufficient to enable the Revenue to impose a tax charge. We will come on to talk about the case law in more detail because there have now been a number of cases looking at the Revenue's view of the way that EBTs ought to work on the personal tax side, and those cases to a large extent are still going through the courts. The other area, which is also key, is looking at the disguised remuneration legislation, which was first announced 9th December 2010, came into full effect 6 April 2011, and continues to be an area of great complexity and also great difficulty.
You allude to the Revenue not necessarily having authority on its side to support its contentions. So what exactly is the strict legal position as regards the use of EBTs for delivery of remuneration and benefits?
The legal position, I think we still have to say, is uncertain. And the reason I say still have to say is that the revenue will still assert that the position set out in Spotlight 5 is a correct statement of the law. But there have been a number of cases looking at both the corporate tax and the personal tax. And today we're more concerned, I think, with the personal tax and the corporate tax. And I've put on the slides here a number of the cases where the revenue have challenged the operation of EBTs in the broadest possible sense. And the reality is that when we're looking at a structure with the sub-trust, sub-fund arrangement, which I talked about, the revenue have consistently lost cases where they've asserted that there ought to be income tax and NICs on the funding of the EBT, or alternatively on the allocation to the sub-funds. So going through the cases briefly, I could spend a long time going through an analysis of the cases, which I'm not proposing to do. But to go through them briefly, the first case which was looking at these sorts of issues was the Dextra case. Now, Dextra is a well-known case because of the decision on the corporate tax side, where it was found that the company did not obtain a corporation tax deduction at the point of funding the trust. But the case was also concerned with an HMRC assertion that tax ought to be chargeable at the point when monies were put aside to benefit employees, partly on the basis that that was a benefit in itself, and the courts found that that was not correct. Putting money aside to provide a benefit is not a benefit, it's the subsequent provision of the benefit which is important. And it was also a case where the revenue sought to establish that loans which had been made to the key beneficiaries should not be viewed as loans because they were not in reality going to be repaid. And that was rejected also by the courts and was not appealed by the revenue at that stage. The second case related to a company called Sempra Metals. And this was a case where the HMRC were asserting the position set out in Spotlight 5 that you had to look at the nature of the trust, that what was happening on a realistic view, that realistically on the facts of the case, individuals did have access to the underlying trust assets, and therefore they should be viewed as having received them for employment tax purposes. And that was rejected by the commissioners. The unfortunate aspect of the case in many respects is that for a number of reasons, although the revenue had intended to take the decision to appeal, it didn't go to appeal and it was settled out of court. And as a result of that, the case did not resolve the issues relating to the Spotlight 5 position asserted by the HMRC as clearly as it might have done. A case which the revenue are keen on quoting is the Aberdeen asset case. And this did involve a trust. It did involve something which in the case report was described as an FBT, a family benefit trust, which is just really another way of talking about an EBT. And this is a case which the revenue won. However, the fact pattern was different from the norm which I set out earlier, in that it did not involve sub-funds, but involved the revenue looking at a set of facts which involved a complex structure with two trusts, money box companies, and a question of whether options which were granted to the trustees of the second trust should in reality reduce the value of shares in the companies awarded to the individuals. And on those fact pattern, the court concluded that the revenue were correct to say that in reality the options should be ignored for the purposes of determining the value of the receipt of shares by the employees. On the facts of the case, I think that was probably right, but it does not support the revenue's assertion on Spotlight 5 on a more general basis.
So just to summarise so far, it appears that the revenue, accepting that earnings are charged to tax on a receipts basis, and the question therefore is when has the remuneration been received? And their assertion appears to be that in the context of the use of EBTs, the remuneration is received and therefore falls to be charged to income tax under Section 18 as at the time when the assets are put into the sub-trust or the sub-fund, presumably on the basis that the revenue takes the view that at that point in time onwards, the individual has de facto control of the assets. Are there other cases that have gone on to examine that?
Well, I think that is a very accurate description of the way the revenue are approaching EBTs, and it also highlights, in my view, two of the difficulties which HMRC have. The first is that their assertion to be successful requires them to be able to demonstrate that despite the existence of the trust, that the reality is that the individuals can access the assets on request. And the second is that it's predicated on a very fact-specific argument, so that it's difficult for the revenue to win one case and necessarily translate that over into other cases. And I think that's demonstrated by the Aberdeen asset case. It's also demonstrated by the PA Holdings case. And in terms of the actual decision, I would say that the PA Holdings case doesn't have any relevance here at all. The reason that I've included it on the slides is because the revenue would disagree with that. And I have certainly seen occasions in correspondence where the fact that the revenue won the PA Holdings case is cited by them in support of their position in Spotlight 5. However, the case did not involve an EBT with sub-funds. The employees did receive cash, and the case was not concerned with the question of the receipts basis, but the question of whether amounts which clearly had been received should be taxed as dividends or whether they should be taxed as employment income. So I have difficulty seeing that the case looked at objectively has very much relevance at all to determining the correctness of the HMRC assertions in relation to the wider EBT arguments.
Very often in these situations, the money that has been put into the sub-trust or the sub-fund is then loaned on out to the employee or members of his family. How have the revenue sought to attack that sort of arrangement?
Well, I think another case there is, the correct name of the case is the Murray Group, although it is more widely known as the Rangers case. It's the case which involved Rangers Football Club. And this was a structure which was very close to the conventional EBT with sub-funds I've talked about. The fact pattern was highly favourable to the HMRC. We referred to on the slides to the trustees being largely compliant. I think the terminology used in the decision was that the decisions of the trustees were formulaic, which is another way of saying they did what they were told. In one instance where the trustees did not do as they were told, the trustees were removed and replaced by another trustee. It was clear on the facts of the case that the amounts which were set aside into the sub-funds and which were largely lent out to employees were replacement for salary. And the reason why that is so clear in the case is a feature of the nature of the remuneration of footballers, where there's the requirement for remuneration to be in the contract of employment. So there was a lot of fact pattern there which was favourable to HMRC. I think it's fair to say that the general expectation, not only of the revenue, but also of advisors, is that this was a case which the revenue would win, because it had been carefully chosen and the facts were so favourable to HMRC. The reality is that the revenue haven't won. They've lost at both first instance and second instance. Highly controversial case. The revenue, I know, were considering taking an appeal. I don't know whether they have decided to proceed with that or not. As far as I'm aware, it's still under consideration. But I think it's a reasonable question to put to the revenue when debating the legal position in Spotlight 5. If you can't win Rangers, which case do you think you can win? So I think that really leads to the conclusion that the revenue's basic position as set out in Spotlight 5 and by inspectors is, I've used the word suspect, I think that's probably being generous to the revenue, and is not supported by the relevant case law. And what that means in practice is that when looking at the question of whether or not to seek a settlement, the main consideration is more likely to be the application of the disguised remuneration rules going forward than the risk of the revenue succeeding with a legal challenge.
The Murray Group case was an interesting one to read, because rather like was it the Tarantino film Reservoir Dogs, all the players were referred to by code names. And indeed, I think even yours truly appears briefly as Mr. Oxford in the case. Moving on then, what is the settlement opportunity?
The settlement opportunity is an opportunity announced by the Revenue in April 2011. And in essence, what it is saying to taxpayers, and we'll go into more detail as we go through, but the headline is that if a taxpayer is prepared to, and by a taxpayer I really mean the company, because first and foremost it's a PAYE issue that we're looking at, is prepared to accept tax based on the position set out in Spotlight 5, to accept that there was a tax charge at the point of the allocation to the sub-funds, and accept that therefore there will be, in effect, interest for late payment, that the Revenue will accept that as full and final settlement of the liabilities arising. In other words, they won't pursue penalties, they won't pursue other arguments through the courts. And as we'll come on to see, this is linked in with the operation of disguised remuneration and wider revenue policy.
So in effect, they're asking taxpayers to accept a position for which the Revenue themselves have no actual clear legal authority.
Yes, I think that's right, and I think that as a result of that, when becoming involved in settlement negotiations, I often find that the nature of the discussion becomes somewhat hypothetical, in the sense that in order for there to be a settlement, the taxpayer has to accept a position, accept for the purposes of determining the settlement, a position which is not correct in law. And this is where you then get into an analysis of whether or not it's appropriate for settlement to be sought. There is a lot of detail which is linked in with the settlement offer, and the result of that was that the Revenue issued FAQs in August 2012, which sought to provide greater clarity in relation to the way that the settlement offer would be operated. And also what came out of that, which is I think an important point to bear in mind when we go on to talk about the basis of settlement in a moment, is that this is part of the litigation and settlement strategy. In other words, the Revenue will be looking at this as part of their policy of saying that if they believe that they can win a case, they will litigate it, and they will, however, in principle be prepared to settle, but only on the basis of what they believe to be the correct position as a matter of law. And that's why we get to this position that the settlement is on the basis that payments into trust prior to 6 April 2011, i.e. the disguised remuneration cut-off, are treated as employment income.
And taking each company or employer company involved, how would they know that they are able to settle?
As of today, if a company has operated an EBT in the way that we've described, where there have been cash put into the trust, there have been allocations to families of employees, there may be variations on the detail of how each trust is set up, but that you're in a scenario there where the assets, based on the Revenue Spotlight article, are available for the employees at the discretion of the trustees to make loans, to purchase properties or whatever, then provided that the settlement negotiations are commenced before 31 March 2015, then in principle there's no reason why that would not be suitable to be brought within the settlement offer.
So what is the tax position once a settlement agreement has been reached?
The basis of the taxation is that the payments allocated into the sub-trusts or sub-funds prior to 6 April 2011 are treated as employment income. Now, what that means, self-evidently, is that they are then subject to PAYE, which ought to have been, in the Revenue's view, paid over at the time of the allocation, and subject to NICs. As a consequence of that, there will be interest on late payment, but provided that the settlement comes within the terms of the settlement offer and is negotiated with HMRC, there won't be any penalties. Now, this is where it gets more complex and where the FAQs and the experience that we've had with HMRC come into play. And I set out on the slide some of the areas to be considered. I should caveat my comments by way of saying that the points that we're going to cover are not exhaustive of all the issues which exist. They become highly complex and on occasion can require a lot of care to unravel.
Perhaps that's a good point to just point out that whilst I've been asking some questions, if any of you listening have any questions, please click on the questions button and type in any questions, and we'll see if we can address those satisfactorily at the end of the talk. Stephen, sorry to interrupt.
No, that's fine, David. I would hope that there will be questions, because there are certainly complexities, and we can't really do more in the 45 minutes we have than scratch the surface. So I think that the first area that I've highlighted is the credit for the corporate tax deduction. So the question is, well, what is this credit for? And I think this is important. If you've been involved in this area, you will hear people saying, oh, well, we've settled with an effective 25% tax rate or sometimes lower. So what is this credit for? Because it's this point which is one of the key features in getting to that position. And I think this requires us to go back to think about the basis that the revenue have for their assertion that tax is due and the consequence of that. Because if the revenue are correct in the position that they have set out in Spotlight 5, what it means is that in effect the trust is being ignored for tax purposes. The amounts which are paid in and allocated to the sub-funds are treated as received and taxable in the hands of the employee. And the consequence of that is that while PAYE and NIC should have been paid, there should also have been a corporation tax deduction given at the time of the payment, which would not have been claimed in most cases because of the specific rules introduced following the Dexter case to stop corporation tax relief for payments into trusts which do not give rise to a tax charge. So the basic requirement for the corporation tax deduction is simply that corporation tax relief would have been given for the payment of the amounts if they had been treated as normal remuneration. And in most cases, that means that there will be a credit, and the effective rate of tax required to achieve a settlement can be reduced substantially. Now, having said that, the facts of each particular case still need to be thought about quite carefully, because the revenue are not simply saying we will give a credit for an amount calculated by whatever the corporation tax rate is or was at the time. What they're saying is that if there could have been a corporation tax deduction claimed with an immediate impact on the amount of corporation tax payable, they will give credit for that. So one particular example which I've highlighted on the slide is the impact of carry forward losses. I had a case a couple of years ago where there had been an EBT set up by a company which had subsequently been acquired by a private equity house, and the contributions were made at the time when the company was in private equity ownership. The consequence of the private equity structuring was that for tax purposes the company made substantial losses, and the result of that was that the revenue said, well, we accept that these amounts would be deductible for corporation tax purposes, but you can't use them. You can't use them because there are already losses which will take priority. And the result of that was to have the effect of the settlement amount being increased substantially. And although we got to a settlement position, I think that the individuals were probably disappointed at the effective rate of tax resulting from the settlement, because they didn't get the benefit of this credit in the way that would often be the case. In most circumstances there will be that credit there, but it is fact specific and therefore needs to be reviewed quite carefully.
Just before we go on to NICs and IHT, thus far the conclusion that many listeners might glean is that whilst the revenue are seeking settlement and whilst they have no specific legal authority, it begs the question, well, why settle at all? There must be some carrot or incentive to companies to come forward to make the settlement. And I wonder if we could say something about the the benefit that can be gleaned from settlement?
Yes, no, certainly. I mean, I'll come back to talk about the NIC and IHT and other issues in a minute. I think that to answer that question, we need to jump ahead slightly to the bottom of the slide and look at the effect of the paragraph 59 credit. Now, the phrase paragraph 59 credit probably doesn't mean much to many people listening. Paragraph 59 refers to paragraph 59 of the Finance Act, which introduced the disguised remuneration rules. And what it says in broad terms is that if you have a settlement with HMRC, then there should be, provided there's no future funding of the trust, so we are only looking at the assets within the trust, and those assets have all been brought within the terms of the settlement, there will be no future disguised remuneration charges. And what that means is that many of the difficult issues with managing trusts that we come on to talk about in a few minutes will not apply, because there simply should not be future DR charges. In addition to that, it's not actually a result of the paragraph 59 credit as such, but as part of the overall assessment of the attraction of whether or not to settle, the revenue accept that assets held within an EBT, which is an offshore EBT, properly operated offshore trustees managed outside the UK, is that there will not be CGT in relation to gains realised by the trustees within the trust. And therefore, the combined effect of the paragraph 59 credit together with that protection from capital gains tax means that there may well be scope for particular trusts to be operated in effect on a gross basis without any tax charge on future gains or on future distributions. When I say that, I'm talking about employment tax charges. There is still the potential for general tax charges, including Section 731, which I'll come back to in a second. But the issues with employment tax should largely fall away.
So there is some real positive benefit to settling in the right circumstances. So, for example, if 100 was put into the subtrust and settlement is reached on the basis that income tax and NICs are accounted for on that 100, as well as a corporation tax deduction being allowed for the 100, and that has been invested and grown to, say, 500, then the effect of the settlement would be to allow that 500 to be withdrawn from the EBT without triggering any further earnings charges to income tax under the disguised remuneration rules.
That's absolutely right. I think we're going to talk about that in a bit more detail in a second. I would just like to touch on a couple of the other points, which are probably not as significant in the overall scheme, but are important to understand. The first one there is the reference to NICs. This is quite a narrow technical point, but it's quite important when calculating the overall amounts due in order to achieve settlement. And the point here is that many trusts were established with terms which said that the trustees could not make a distribution or provide another benefit which resulted in there being an NIC charge on the company, and that was written into the terms of the trust. And the result of that is that the revenue have even more difficulty asserting that the individuals have unreserved access to an amount which includes an amount which would have to be paid to the company, the employer, in the event that a distribution was to occur. And as a result of that, where those provisions are held within the trust, the amount required to settle will be capable of being reduced by that NIC equivalent amount. And that's another feature which helps then to reduce the overall effective rate of tax. Going the other way to some extent, I've referred there to inheritance tax. I'm not proposing to spend much time on this. I could spend a long time on it. But the basic point with regard to IHT is that the revenue do not accept that a trust with assets which are held within sub-funds continues to benefit from the reliefs from inheritance tax for discretionary trusts which are treated as employee trusts for inheritance tax purposes. Now, there's a big debate about whether the revenue are right on that or not. The practical point here is that the result is that the revenue may assert that there ought to have been IHT paid at the time when money or other assets were put down into the sub-funds, and that may result in there being a component of IHT chargeable and included within the computation of the settlement. Generally speaking, that's not actually a big issue, because even if there is IHT, it will be typically for a small amount, but nevertheless needs not to be forgotten. And the second point is that the revenue will assert that if the assets continue in the trust post-settlement, that they will continue to be subject to the IHT charges applicable to any other form of discretionary trust. So, in other words, IHT charges on the 10th anniversary of assets going into the trust, or if there is an exit, a distribution of assets not subject to income tax, bearing in mind there that the distribution may well not be subject to income tax because of the paragraph 59 credit.
It has been said that there is only ever a liability to IHT on settlement in the case of closely controlled companies. Is that strictly correct?
No, that's not right. I have heard that said, and I think the reason for that is that there are a number of specific rules relating to inheritance tax on closed companies, and they are covered in the revenue statements at the time and a bulletin that the revenue issued, which I think was IHT Bulletin 18/11. However, there are 2 points. The first is that the IHT rules I've just been talking about relating to the trust are not specific to closed companies. And the second is that the revenue now accept that if you have a trust which is funded by a trading company and funded with cash, that will not result in IHT charges at the point of funding, simply because of it being a closed company.
So, what factors come into play when a company is sitting down to determine whether they should positively seek a settlement?
Well, I think that there are a number of factors. I think that we've talked at some length about the HMRC challenge Spotlight Fire. For the reasons I've given, I think that's unlikely to be a reason to settle due to the weakness of the revenue position. I think that it's more looking at the interaction of potential for future disguised remuneration charges linked with the potential benefits of settlement with paragraph 59 credit. And I think there are a number of reasons, therefore, to settle. First of all is resolution of reputational issues. For better or for worse, EBTs have acquired a poor reputation. Whether that's fair or not is a completely different question, but if you've got a corporate transaction pending, I have certainly seen cases where the existence of an unsettled EBT within a group being acquired has created a significant problem for the corporate transaction. There are potentially low costs of settlement, the effect of the credit for the loss of the CT relief, effective of the reduction for the NIC amount, you've got the continuing CGT protection. I think also there ought to be thought given by individuals to the potential for longer term family planning through the use of trusts. I think one other area which we ought just to remember is this question of the impact of section 731, which we have alluded to in the previous slides. And the point with section 731 is that it is a particular anti-avoidance section under which the revenue assert that if income arose within the trust, just by normal investment, that's something which cannot be washed out by the settlement with the revenue on the employment tax side, and therefore there can be continuing section 731 liabilities. And I just mention that because it's something which has been subject to debate with the revenue recently, and their policy, I think, is now fairly settled. It may not affect many trusts, but where it is relevant, it can be of quite a significant effect.
I know one of the situations where that may well come into play is where the assets in the subtrust have been all invested in offshore funds, and rather than in assets where there is shelter from those Section 731 charges. Moving on then, what is your practical experience of running settlement negotiations?
I think it's fair to say that it's been varied. Settlements certainly have been completed, and that is obvious in a way from the press release that the Revenue issued relating to the withdrawal of the settlement offer, because within that they quoted an amount that they have received through settlements of £800 million. I think it's important when...
Not a lot in the context of the whole debate.
No, I agree. I mean, I think there's an interesting discussion to be had about what that implies about just how successful the settlement offer has been. When you're looking at the amount of tax that would be due, being broadly speaking 40% of the amount that went in, this funding was typically when the tax rate was 40%, plus the NIC amount, albeit taking account of the credit for the corporation tax relief, I would actually have expected the amounts recovered by the Revenue to be substantially higher. There have been some well-publicised trusts with some very large numbers which have been contributed, and the 800 million figure sounds like a good headline number, but to my mind implies that the proportion of trusts and trust assets which have been subject to settlement is not as high as the Revenue would like us to believe. And I think that part of that is that the process of settlement is subject to all the variable factors as I've talked about. If, as an individual, you're looking at a circumstance where you've got substantial assets in there which you don't have any immediate need for, maybe viewing the assets and the trust as part of inheritance tax planning, it may well be that you conclude that you do not wish to settle. I think that now is the time for companies and for individuals to reach a conclusion as to whether or not they want to seek settlement or not. If settlement is to be sought, then it's important to recognise that because the Revenue view this as being very fact specific, and that they are correct in that it will be necessary for the Revenue to understand and have explained to them the detail of the underlying trusts and the related transactions. Now that may be straightforward, but as often as not isn't. And there are many variations of types of trust and types of awards which can be used, which need to be understood. HMRC are concerned with consistency between taxpayers. I've said there, and I would say this to the Revenue, I have said this to the Revenue, that they do not, however, succeed in following a consistent approach internally. And the reality is that over time they have not been consistent with different taxpayers. But nevertheless, that is part of their remit. And what that means is that they are very concerned to ensure that any settlement for one client is not, or customer, to use the Revenue's terminology, is not inconsistent with settlements with other customers. And that can result in a lot of time being taken up, settlements being referred to the Central Committee, being rejected by the Central Committee, then needing to be recomputed in order to reach agreement. So it's important to be recognising that when putting the facts to the Revenue. And as a result of that, settlements do take time. And that ought to be factored into any initial analysis and consideration of whether or not to seek a settlement. The other point is that I've deliberately in the previous slide set out some of the relatively secondary issues. And I think that the point there is that the settlement analysis needs to reflect the full range of issues. It's no use thinking that you can go into a settlement and sort of short circuit some of the points. It's not necessarily the case that each and every point needs to be ultimately resolved, but nevertheless thought needs to be given, for instance, to inheritance tax, for instance, to longer term personal planning.
So, given the 31st March deadline, what exactly should clients and companies be considering?
Well, I think that the first point is that there ought to be a considered decision taken well before then, whether or not to try to obtain a settlement. The Revenue's position is that if there is no settlement, then they will inquire into trusts and there is the potential for litigation. Personally, I'm quite sceptical about that. I think that the position with litigation, for all the reasons we've talked about, is difficult for the revenue. My own view is that a likely outcome of the Rangers decision is that the revenue will abandon continuing to challenge trusts through the courts. I may be wrong about that, and the reality is we don't know. I think that's a likely outcome, but nevertheless, the risk of continuing inquiry and litigation is there. I think there's a question of visibility, and what I mean by visibility is the question of whether this attracts the attention of the revenue to the company's tax affairs, to the individual's tax affairs. Has there been full disclosure? Does this have any potential adverse impact on wider relationships with the revenue? It's not the case that settlement is the right thing for every EBT by a long way. There'll be many EBTs for which it is, but I think it's important to look at the risk profile and the history of the EBT, think about the amounts in the trust, think about the amounts of potential tax liabilities, look at all the factors in the round in order to come to a view as to whether or not settlement is the right way to go.
But let's be clear, if you don't settle, then going forward, whenever any benefit is taken out of the trust or the fund, then as a general rule, that will be within the scope of the disguised remuneration rules, and you can expect to incur an immediate charge to income tax and NICs on the full amount which is taken out.
Yes, absolutely.
And the opportunities for avoiding that are relatively few and far between.
Yes, no, I agree with that. I think that the other area just to think about with future consideration and not to forget is the position of the beneficiaries. And what I probably should have said on the slide there is the beneficiaries and the trustees. And something which companies tend to forget, it looks obvious from the point of view of an advisor or a trustee, but I have seen time and time again that companies forget that in order to reach a settlement for all practical purposes, they will need the agreement of the beneficiaries. If the beneficiaries don't agree, then the company can settle the PAYE liability, but they are in no position, the company that is in no position to require a contribution to that from either the beneficiaries or from the trust assets.
And yet, strictly, when we talk about settlement, what we mean is a settlement of a liability of the employer under a Regulation 89 assessment under the PAYE rules.
Correct. Yes, that's right.
And is it possible then, where there are a number of individuals who have benefited from these sub-trusts and sub-funds, for settlement to be on the basis that it relates to some only of the individual sub-funds?
Yes, and that was a point which was discussed specifically with HMRC when the settlement offer first came out, because originally the revenue view was it was all or nothing, and the point was made to them until you have a trust with many hundreds of employees, which can be the case. What that means is that there will never be a settlement. And the result of those discussions is that the revenue do accept that you can have settlements with some participants included, some beneficiaries included, and some not. The caveat I would have with that, particularly when looking at this from the point of view of any of you who are trustees, is to think through quite carefully what the consequences of that will be. Because if you had a circumstance, take an extreme case where you had an EBT and there's one beneficiary who chose not to participate, everybody else did, then that may well be the right outcome, but it is also likely that that one beneficiary will be in a fairly uncomfortable position, thinking about future costs, management of the trust, etc.
So, moving on then, as regards the practical operation of an EBT post the introduction of the disguised remuneration rules, and whether or not a settlement has been reached, how going forward will the EBT be operated in practice? Because there's a slight conundrum here, isn't there? Almost an Alice through the looking glass situation where the employee and the employer have been treated as if earnings had been paid, earnings on which taxes has been due, and yet those earnings are still locked into the trust or the fund, and typically the individual will have no immediate right or entitlement to claim payment of those funds.
Absolutely, and I think that thinking about the post EBT, post DR position where no settlement is being achieved is absolutely something which trustees and beneficiaries and companies need to think about, probably to be fair in that order.
Or even where settlement has been.
Or even where it has been reached, indeed. I think that certainly if you've got an EBT where you don't have settlement, then as you've said, there will be tax charges arising on any future allocations to sub-funds or loans or purchases of property. There will also be questions about the management of trust assets. The legislation relating to disguised remuneration is broad in the transactions which it captures, and although there are exceptions, exclusions for activity which is investment activity, that's hedged around with some quite detailed exclusions and requirements. So as an example, actions taken at the request or direction of a beneficiary, even if it does not result in a payment to that beneficiary, are likely to result in tax and NIC charges arising if unless one of the exclusions can apply. And that can be particularly difficult when you're looking at transactions, for instance, which involve linked persons as defined by the legislation, which again is not just relatives, but is quite a broad definition of who that might be.
Stephen, thank you. We're just over our allotted time, 3/4 of an hour. So I think what we will do now is have a look and see if any of you listening have submitted any questions. Right, we've got 3 initial questions. The first, if we don't accept settlement and ultimately PAYE, etc., is due, are we not then out of time to get a corporation tax deduction or tax credit?
I think looking at the interaction between the corporate tax position and the personal tax position and the timing point you refer to there is absolutely a good point. When we've looked at this in the context of settlement negotiations, and I appreciate you're talking about if you don't settle, the issue of timing has been one which has been discussed with the revenue and has been problematic. So I'm slightly going to hedge the answer by way of saying yes, that can be a problem. I think it would be what's required is to look quite carefully at the specific fact pattern, look quite carefully at the actual timing, and establish whether indeed there is no way of structuring the claim so that the corporation tax relief can be given. Also looking at the interaction between the personal tax time limits and the corporate tax time limits.
Yes, because one of the areas we didn't have time to cover in any detail this morning is the whole question of the revenue seeking to claim settlement for years that are out of time for them enforcing a liability.
Yes, indeed, and I think that the reason we didn't cover it is because it does. I mean, it is a significant area. It's probably not one of the areas which is sort of top of the list in terms of the impact on settlement, depending upon the particular fact pattern, and whether or not the out of time years can be excluded from any settlement turns on various quite detailed discussions, controversial discussions about the nature of the disclosure given to HMRC when the trust was first set up. The revenue will accept that if full disclosure was given at the time, then that ought to mean that the trust can come within settlement even if they're out of time without tax being paid. But the way that that's applied is in a very limited manner, and is an area of quite genuine difficulty and controversy.
Thank you. Next question. At a recent meeting with the Revenues team members referred vaguely to yet another inheritance tax issue being a potential issue on the writing off of loans that exist if the settlement opportunity is taken up. Can you shed any further light on this?
I don't know which issue they were talking about in particular, but there is a provision in the Finance Act 2013, which may be what they're referring to. Now, what that provision says is, if we step back for a second, the original thinking with inheritance tax was that if you have a loan, then that loan, if it's outstanding at the date when an individual dies, has the effect of being a deduction from the assets of that individual's estate for inheritance tax purposes. And that meant that there was quite an attractive IHT treatment resulting. What the legislation in 2013 said, in very broad terms, was that if a loan is outstanding at the date of death, it will only be deductible for the purposes of the assets in the estate if it is repaid out of assets in the estate. So if the loan is written off, the legislation will no longer accept it as being a deduction for general IHT purposes, and that may have been the point that the revenue were referring to.
Thank you. Another question. Where the sponsoring company that established the trust has been wound up, how does the revenue seek to collect the tax on earnings?
I think I'd actually answer that question from a slightly different angle. I think that the revenue would be coming and looking at that and saying, well, if there is no PAYE payer, then we can seek to collect it from the individuals, because ultimately, although there is a PAYE liability, it is in respect of what the revenue would view as an income tax liability of the underlying employees. The reason I say I'd approach it from a slightly different angle is that where I've seen this come up in practice has been where individuals have wanted to achieve a settlement with the revenue, and that has proved difficult where the company has been wound up for the very reason that the initial starting point was a PAYE liability, and the whole mechanisms, administrative and procedural mechanisms the revenue have in place are predicated upon the settlement being a settlement of PAYE. And where that's come up, what's been required has been some fairly pragmatic discussions with HMRC in terms of recognising that there clearly cannot be, short of reinstating the company, collection of tax from the company, and therefore coming to arrangements directly with the individuals, pretty much on an individual by individual basis, which clearly is difficult if the trust has a large number of individuals. I think the answer is it needs to be dealt with on a fact by fact case.
And I know that in the early days, certain council were putting forward the idea of winding up the employer company as a way of avoiding these liabilities altogether. But I think it was the case that other company corporate council concluded that it would not be lawful to do so, where there was clearly this potential outstanding liability to the revenue. Stephen, thank you very much. We're now well out of time. Thank you for your attention. Our next webinar will be on a broader topic, an update on rules and regulations relating to share schemes generally, and we will in due course post on the website and circulate details of that webinar. If you have any specific additional questions, do feel free to email them to Stephen Woodhouse, stephen.woodhouse@pettfranklin.com. Otherwise, thank you very much for your attendance. I hope you found it worthwhile. Thank you for listening. Have a good day. Goodbye.